Yes, sir.
How you doing?
Good, sir.
All right, we can see we get done.
Okay.
They may have to, I don't know. Like I say, they may have to reset it depending on what the state position, where they able to look at, evaluate it as well.
Okay.
Yeah, so we'll hopefully maybe we can give them another week. I don't know.
Okay.
Okay.
Sir?
Hello.
Yes, the one that is in black shirt.
Yes, ma'am.
Are you sitting, laying? What are you?
Well,
You gotta,
I'm sitting down.
okay, you're in a courtroom, okay? So
All
the
right.
judge will get after you.
So Mr. Segura,
Yes, sir.
we were saying, okay, we were saying that you had these cases in 06 and 08
Mhm.
that completed the you completed the deferred successfully,
Okay.
right? I'm trying to check my notes.
Oh.
You recall when the deferred was completed? This is
Oh. I think it was 2010. That's when they took me out from probation.
okay. All righty. All righty.
Mr. Jones, I'm Matthew Kendall from the DA's office. I do have
Hi.
an objection on the non-disclosure. I will email you right now and let you know what's going on. Okay?
Okay.
Okay.
You have an objection on I think there was 2 cases. Okay, you're gonna email me?
Judge, we're ready. We just, the attorney for the plea is not on, so everybody else is.
All right. Good morning, everyone.
Morning, Judge.
Good morning.
Morning.
The 357
Morning, Judge.
The 307 District Court, 357th District Court will call its court docket set for this morning, Wednesday, January 19, 2022, starting with civil hearing set for this morning, 2021 DCL 4958, Alafa versus Monreal. Mr. Salazar.
Morning, Judge. Miguel Salazar here for Mr. Alafa. The respondent did not submit an answer, and I don't know if she's here on the screen.
Ms. Monreal.
But if
Ms. Monreal, Jennifer Monreal. I don't see her. So it's just, is there any children in this one?
no, Judge, it's a simple proof of no kids, no property.
No property? Then proceed.
Raise your right hand, sir. Mr. Alafa, raise your right hand, please. Can you raise your right hand?
Yes, ma'am.
Do you solemnly swear from the testimony you give will be the truth, the whole truth, and nothing but the truth, help you God?
Yes, ma'am.
Thank you. You can put your hand down.
Mr. Alafa, please state your name for the record.
My name is Enrique Fernando Alafa.
And you're currently married to Jennifer Monreal.
Yes, sir.
And prior to filing this suit, you were domiciled in the state of Texas for the preceding 6-month period and a resident of this county for the preceding 90-day period.
Yes, sir.
And you were married on or about June 2020 and ceased to live together as husband and wife on or about July 2021.
Yes, sir.
And the marriage has become insupportable because of discord and conflict of personalities between you and your wife that destroyed the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation.
Yes, sir.
And there were no children born to the marriage?
No children.
And no children were adopted or any expected?
No, sir.
And there was no community property acquired during the marriage?
No property, no nothing.
But just to be specific, you're asking the court to award any property and debt under your possession and control as your sole and separate property?
Yes, sir. Anything that belongs to me being, anything that's under my name and obviously not under her name, not being hers, anything that's mine will be staying mine.
And likewise, you're asking the court to award any property and debt that she has under her possession and control as her sole and separate property?
Yeah.
And you are asking the court to grant this divorce as stated?
Yes, sir.
All right.
Nothing further.
The court will take judicial notice of all documents. The court will, having called out the name of Jennifer Monreal, no answer has been had. The court finds that it has jurisdiction by virtue of the domiciliary requirements of the family code. The court hereby having heard the evidence of the testimonial evidence of petitioner in support of a suit for divorce hereby grants the divorce is paid for, approves the division of assets and debts as stated on the record. Anything else?
Nothing further, Your Honor. That's all I have. Will the court may be excused?
Thank you for being here. Thank you, Mr. Alfalfa.
Yes, sir.
Thank you, Judge.
All right, 2014 DCL 2374, Hernandez Picasso, Mr. Garza, Mr. Aguirre.
Good morning, Your Honor.
Morning.
Morning, Your Honor. Regards on behalf of Mr. Reyes. This is a status hearing. Ms. Christine Cortez was, I don't know if she's on yet. She was running a little late to get to her office. She has a report for the court.
Okay, well, we need to wait on that because
I see her. She just got in.
Yeah, she's there.
Okay.
Ms. Cortez.
She might have her volume down, so she might not hear us. Oh, there she is. Okay.
Morning. On Hernandez Picasso, do you have a report for the court?
We can't hear you, Ms. Cortez.
Sign language, you want to go out of the sign language?
Can you hear me now?
Let's do my sign language app out.
I'm sorry, Judge. Technology does not like to be with me. Your Honor,
Yes.
good news on this case. Unlike previous times where I would mention that nothing has improved, we have improved. The counselor said that mom did very well in counseling. She says that she's ready to restart her supervised visitation again. The only bump in the road is who's going to be the supervisor. The counselor would prefer it not be the dad because of the tension, and that's not good for the child. So she's suggesting either third party or paid. I will leave that up to.
And Your Honor, because of our limited funds, Your Honor, we're asking that a third party be allowed to be there, Your Honor.
Be what, Mr. Aguirre?
Be allowed to be a third party, a family member of hers or a church member, somebody that will not require payment because she has limited funds.
Well, I think both Mr. Garza and Ms. Cortez are aware of the financial situation, right?
Yes, sir.
I don't think it's evaded any of them, us. So give me some choices between Mr. Aguirre. If you made that suggestion, throw something at me that I can sink my teeth into, you know, give me a suggestion as to who and what, you know, you've been, you know, having consulted with your clients, you know her better than any of us here. What would be a good suggestion?
Yes, sir. There was an aunt that was doing it, but she's an older lady, and it was difficult for it to be all the time. What I'd suggest is between the aunt and her church has a woman's section, which we can get someone to go with her from her church.
Here's what I want to do. I don't have any. Let me hear from Mr. Garza. Go ahead, Mr. Garza.
The only thing I'm concerned about is I understand Ms. Cortez feels the counselor says she's ready, but my client had conveyed to me last week that the counseling wasn't going well. And so I just want to make sure I'm going to ask him on the record at what it is exactly that he understood the counseling wasn't going well, why that is, because if Ms. Cortez says it's going well, I have no doubt that that's what she was told, but my client seems to have a different opinion. I just want to know what that opinion is.
I understand. Let me ask you something.
Your Honor, before we continue, if we're going to...
Hold on, before we get off on that rabbit trail, let me just clear up something. The counseling that was ordered for Ms. Picasso to undergo was a counseling between her and who? And the counselor, who else?
It was going
was
to.
involved in the counseling? Yes.
Your Honor, the counseling was basically for mom, for her to understand what's proper to say in front of a child and what wasn't proper to say in front of a child, because she was saying stuff that she thought was okay.
Was there anybody else involved?
I believe Suda Bernaji did a visit with the child as well.
Who? Oh, she did visit with the child? Right.
Yes, Your Honor.
Well, I'm just kind of curious, Mr. Garza, to know how your client would know how it's going in a supposedly a confidential atmosphere in this counseling. So that would be interesting for me to find out. Is he on the screen?
Yes, Judge. He's wearing a light blue shirt. He's at work right now.
Answer that question, Mr.
Your Honor, before we continue, that's what I was going to mention. Since we were just giving summaries, now that we're going to have a testimony, we do need an interpreter.
All right. Well, we'll get an interpreter. I just want to clear that up for the court because
yes,
I was on my way to summarily dispose of that with your suggestion, Mr. Aguirre.
Yes, sir.
All right. So, but I have to give Mr. Garza an opportunity. But before I do that, we get into a full-blown hearing. I want to clear up what's going on here. Mr. Hernandez.
Yes, sir.
How did you become aware of what was going on in the counseling session enough for you to form an opinion that things were not going well?
On the last visit that my daughter had, the last time that my daughter went to Misuda, it was between her mom and my daughter and my daughter's siblings. Misuda gave my daughter time to spend with her siblings, but when it came time to meet up with mom, my daughter came too emotional, and Misuda had to end the meeting right there. They didn't even had a chance to go on. They said they were gonna postpone it for another day, but I never heard nothing from them.
All right.
Your Honor, I can ask when that occurred because I spoke to Suda a few weeks ago. So when did that occur?
When did that happen?
I don't remember the date exactly, sir, not on top of my head.
A week ago, 2 weeks ago, a month ago? When?
It's about a month ago.
Okay. Well, we've had an update, apparently, according to Ms. Cortez, that since then, everything seems to be going all right. Here's where I have a concern with you knowing all of that, Mr. Hernandez. Obviously, your daughter is imparting that information to you, and I certainly hope and pray that it's not at your prompting. It's not because you're asking her questions. about
No, sir.
how to go into session. And nothing like that, because I would think that would be not acceptable to me that you would be doing that. First of all, because again, it goes back to the same issue that I have in this court time and time again. That I'm
I
out
don't
here.
indicate and ask my daughter anything about that.
Hold on, sir. I'm here to look for the best interest of the child, including yours,
Yes, sir.
especially yours. And that's why we're doing this, because I'm concerned, and I was concerned about what's going on in the Picasso home. So that's why we're here. So
understand.
I do not think for 1 second, Mr. Hernandez, that the child should be really, other than what she's doing, not be questioned, asked about, or even want to know about what's going on in the council session. I think it
I
would
don't
be,
ask her none of that.
I think it would be better for her to get us to where we need to go, and the purpose of the counseling, without her having to externally offer explanation of what's going on to you or to anybody else, except Ms. Cortez, of course, because she's appointed by the court. But Ms. Cortez has told us that things seem to be going well, and that we now are at the cross point where we want to figure out who would be a best person to chaperone this visits with Ms. Picasso. Do you
Your
understand?
Honor, Your Honor, because I was worried, I did contact Ms. Barnagy right now. She said, again, she's reiterating again that supervised visitation, she wanted to be supervised, just not by dad, but supervised visitation.
Okay, so that's where we're at. Okay, Mr. Hernandez? All
Yes,
right,
sir.
so I get the ball's back in your court.
In Your Honor, like I stated, we can have the aunt, and if the aunt can't be there, then a lady from church, I can't give you a name, sir, because there's about 20 different ladies that can accompany.
That's what I want you to do then.
Yes, sir.
If you would for me, please.
Yes, sir.
I'd like to get whoever you set on, one of those 20 ladies you set on,
Okay.
who's willing to do this. This has to be a full explanation of what we're gonna require them so that they can do it with open eyes.
Yes, sir.
Accept the responsibility of supervising these visits. I want to reset this for you to come back to me and bring me that lady so I can talk to her.
Yes, sir.
Will that do okay?
Yes, sir. If I can have a week, I can get you I can talk to them.
Mr. Garza, you're welcome to tune in, but it's just a matter of me deciding, but whether or not we're gonna appoint this lady to help out doing this supervised visitation as per the counselor's assessment.
No, Judge, I just would say my client is very much wanting to get the mother and daughter together. And whoever the supervisor is, the daughter's 14 now. She's getting older. She's very vocal. She'll tell dad, hey, it didn't go well, it did go well, these type of things without dad prompting her. And we'll know real quick if the supervisor's not there or if there's something happens because a girl reported to dad. That's what, as she has been doing. So,
well, if that's the case, then we have no issue here because I understand those things. I mean, especially when they get older, they are able to vocalize without any prompting and on their own. Share it with Mr. Hernandez. Dad, today's session went downhill. But it could have been impromptu like that, So I understand that. I just want to make sure that none of the other one is going on. What Mr. Hernandez and I talked about. Okay, so give me a week so I can find out who we're going to put this supervision in whose hands.
January 26th.
January 26th, Mr. Aguirre.
Yes, sir. We'll be here.
Judge, just real quick, I just want to make sure that maybe there was a little bit of a mix up when Suda was explaining to me. She did say that the child did get emotional, but she was getting emotional because she hadn't seen her siblings in so long. And so she was crying over that.
Okay.
So
I think things are rolling, maybe not smooth as I want them, but they're rolling in the right direction. But
yes, right.
The flat tire is rolling. Let's go. So let's keep it going this way. I think this is a good way to work it out, get everybody to where they need to get. All right.
Thank you.
Thank you so much.
May I be excused to the 26th?
Yes, sir. Have a good day.
Thank you.
Thank you, Your Honor.
Thank you. All right, 2021 DCL 4779 in the matter of Roman Segura, Mr. Jones.
Yes, good morning, Your Honor.
Good morning.
We talked to
Deputy
the
Kendall for the
state
state judge.
Okay, Mr. Kendall, what's going on? Do you have any objection to the non-disclosure flyer filed by Mr. Jones on behalf of Roman Segura?
Partial objection, Judge. There are two two charges, or I mean, two cases, I guess you would say. And we object to the first case, 06 CR 1609.
On the basis of?
While he was on the deferred adjudication in that case, he was placed on deferred adjudication in the second case. The code requires that in order to get a non-disclosure that you must not have been convicted or placed on deferred adjudication when it's a felony for the time that you're on the deferred plus 5 years afterwards. So the second one, we don't object because he wasn't placed on another deferred or convicted of any crimes during the second one that we know of. The first one, he was, though. So we object to that one.
All right, Mr. Jones.
Your Honor, we reviewed the law. That seems to be correct. And we were asking for that second 08 offense to be non-disclosed only.
All right. So do you have an order to modify it and then just put in the one that it's eligible for non-disclosure?
I can get that. I can get that e-filed, Your Honor.
All right. If you prepare that and have Mr. Kendall review it for whatever, anything else, and if he's okay with it, I'll sign off on it. Okay.
Thank you, Your Honor.
It will be granted to that extent.
I appreciate it.
Thank you, Mr. Kendall.
Thank you, Judge. That's all I have. May I be excused?
Are you still at the Supreme Court or what?
I am, Judge.
Give me an address so I can forward you my rooster. Have a good day, Mr. Kendall.
Thank you, Judge.
Have a great day, Your Honor.
A little levity on a Wednesday here. 2020 DCL 899 Slovak versus Farmers Texas Insurance. Mr. Green and Mrs. Thaddeus.
Morning, Your Honor. Beth Thaddeus for defendant.
Morning, Judge. Jorge Green for Mr. Slovak.
Okay, what are we doing on this one?
Good morning, Judge. Aida Montanaro, present for Ms. Alma Slovak. She's been served as an intervener.
Okay. All right, what's going on this one?
Judge, the reason we're here is because we settled this first party case for $20,000, and Farmers didn't send me $20,000. They sent me $17,933.60. They withheld $2,066.40. And the reason that I think that they're withholding that money is because there has been a claim made that somebody else owns part of this disputed case. And so it's a first party case where there was a third party settlement for $30,000. And in that first party case, the lost wage claim was satisfied. And so in the second part of the case, when there was no more lost wage claim, Mr. Slovak's ex-wife has come forward claiming that she's owed something. And Farmers, what they did is they went back to his deposition testimony. They figured out from his deposition testimony by the number of days he missed and how much he would make that $20,66.40 was the amount of his lost wage claim, and they've withheld that. If Mr. and Mrs. Slovak want to fight about this, Judge, I think they've got to go fight about it in family court, because this idea that Ms. Slovak automatically gets half of $20,66.40 is just absolutely ridiculous, starting with the fact that every single one of these claims was disputed. It's not like Farmers came forward and said, yes, we agree that we owe all of Mr. Slovak's medical bills. We agree that we owe all of Mr. Slovak's lost wages. We agree that we owe him for his pain and suffering. We agree that we owe him for his mental anguish. We agree. I mean, they didn't agree to anything. This case literally settled on the morning of trial. And even if $20,66.40 was the amount of the lost wages, Judge, Mr. Slovak is paying attorney's fees on that. He paid costs in mediation, in depositions, in all of the taxable court costs that it took to get the case to literally the morning of trial. On top of that, the CPRC says that Farmers doesn't owe $20,66.40. They only owe the amount due after taxes. Another reason Mr. Slovak doesn't owe this money is because the live pleadings in this case do not state a claim for lost wages. For all of those reasons, Judge, and there's more. I mean, I've got a list here, but we could have a 30-minute hearing on this. They ought to go fight about this in family court. And Judge, I'd ask that you order Farmers to send me the difference, which is $20.6640.
Judge, if I may.
Your Honor, I'm sorry. I believe I'm defendant.
Let Ms. Arias go and consider.
Okay. Your Honor, actually, his live pleading does state a claim for lost wages. I filed it. What I did, Your Honor, to be on the safe side, is I filed a petition in an interpleader. I forwarded the $17,000 to Mr. Green. I kept back. What we did was we figured out what Mr. Slovak himself testified to, which was $4,132.80 in a lost wages claim. We divided that in half and kept that back and deposited it with the registry of the court because this is disputed funds. We received an email from Ms. Montanaro that she had a claim, her client had a claim to this money. And for Mr. Green to say that there was no lost wages claim in the underinsured motorist claim is disingenuous. It is in his live pleadings. And we did reach settlement.
Go back to the file, at it, but okay. I don't understand why you care who gets the money. Why do you have a dog in this fight?
Your Honor, I don't want the former Mrs. Slovak to come back to Farmers and say, why did you pay him this money when I had a clear claim to it? It's very clear in the order signed by the court that she is entitled to half, and it specifically states this, mentions this case number.
Ms. Arias, what order is that?
It's the divorce case number, Judge, 2020 DCL 3310.
It should be in the pleading. It should be in the court file, Your Honor.
Mr. Slovak signed a release that Farmers asked for, and Mr. Slovak has indemnified Farmers for all of that. There's no risk ever that Farmers is going to have to face any consequences for sending Mr. Slovak the money that they agreed to pay.
Judge, if I may, for my client, if I can speak for Ms. Slovak, I think I'm the only one that hasn't gotten the opportunity to give my client's side.
That's correct, because you're the intervener, and I usually hear the intervener at the end. But
yes, Judge. So divorce case number 2020 DCL 3310 in the matter of the marriage of Alma Slovak and Bob Dan Slovak. This was finalized, Judge, in the 445th in front of Judge Gloria Rincones on December 1st, 2020. Mr. Garza represented, Mr. Reynaldo Garza represented Mr. Slovak. We went to mediation. We had a very hard time reaching an agreement in this case. There was multiple violations throughout the case by Mr. Slovak, but we finally reached an agreement. And part of that agreement that we put on the record, and that Judge Rincones, who is family board certified, agreed to this agreement, would be that Mr. Slovak earned money during his marriage. He owed her half of any lost wage claim that we had to this cause number. And we specifically referenced the case that is before this court today. Now, the fact that Mr. Slovak's counsel is making the argument of Farmers have no dog in this fight, they shouldn't be worried about liability. What he should be worried about is a liability to his client for not following a court order that he agreed on the record. So that's where my concern is. But again, this has been put on the record by the court. This is a contract. This was signed to by all the parties. So they're trying to take advantage of the fact that maybe this isn't before the same judge.
Yeah. Well, here's the way I'm digesting this. At the very minimum, since we do have a divorce decree that says this and refers to this case, so there's obviously notice to everybody that there was an interest, some sort of interest in this thing. But having said that, I don't think that the divorce decree addressed if he recovered, and by the efforts of counsel, Mr. Green, to recover this. So proportionately, whatever she gets is going to have to proportion with the expenses were incurred in securing the settlement. That would be fair. meaning that Mr. Green incurred and Mr. Slovak incurred expenses to get the lost wages. It wasn't like it was automatically given to him as a matter of just because you're an employee, here's your check. It was a disputed, contested matter that required counsel to advance the interest of Mr. Slovak. That counsel incurred expenses in doing that. Those expenses should be shared proportionally between everybody that received a benefit from the settlement, including Mrs. Slovak. At the very minimum, that is what fairness calls for. So if you recompute, subject to your approval and subject to review, all the expenses Mr. Green incurred to try to advance the case against farmers, and you review them and they're reasonable, then you proportionally address that with the benefits that Ms. Slovak is going to get and what Mr. Slovak got. At this point, it looks like you'll be almost, I mean, off the top of my head, somewhere between 80-20, maybe. 80% Mr. Slovak, 20% Ms. Slovak, somewhere around that, it looks like from the figure.
If I may,
And the court will not issue an order that contradicts another court order in a divorce court. I can't do that.
well, Judge, and that's where my objection lies. By ordering Ms. Slovak to pay half of the attorney's fees for Mr. Slovak, that would substantially change the divorce decree that's in place with the 445th.
I did not say half.
Well, a proportional amount of
Right.
his attorney's fees.
Right.
I'll speak to both. I'm happy to speak to both counsel on the case. And I'm also going to speak to my client, but I know that I said this in writing to an email to Mr. Green, but he should really be considered that his client is well aware of the agreement that we put on the record before the court. And I am really considering filing for and asking for attorney's fees within that court because he was well admonished by Judge Rincones. And so I'm happy to talk to them.
That is a dog fight. That is a proceeding that I have nothing to do with it. That's your choice. You are welcome. You have that forum, and there is a valid order there, that divorce decree that you can certainly lean on to do any claims over there, but it's not here.
Yes, Judge. I just want to make sure I have it on the record.
Sure.
And Your Honor, I just want the funds with the court because
what I'm going to order farmers is to interplead the $20,000 into this case.
well, the $20,000, I've already given Mr. Green $17,000 of it. And so it's just the $2,000 that has been interpleaded at this point.
But counsel, I think that under the circumstance, you should interplead the whole amount. If you already gave 20, you interplead the rest of it. And this
So
court
then
will
Mr. Green will have.
This court will issue an order depending on what Ms. Montanaro says after conferring with Mr. Green about all this stuff. Come back to me and I will release the funds accordingly.
Okay, then, so you're ordering Mr. Green to put the $17,000 that we've already.
The 17,000 is not in dispute, or is it?
No, Your Honor, but if Your Honor is saying you want
No, I'm not
the whole
ordering Mr. Green
20,000.
to do that. I'm ordering you to deposit the remaining of the $20,000 settlement into the registry of the court.
Okay, we've already done that, Your Honor.
Okay, then you've done your job for the to interpret the funds, and you can wash your hands from this, and it's between Mr. Green and Ms. Montanaro from now on how they choose to address the situation. Okay.
Thank you, Your Honor.
Thank you. So here's where we're at, Ms. Montanaro, Mr. Green. I'd like you all to confer, talk about it, and try to see if you can mutually agree to something here that, well, I understand the argument Ms. Montanaro has, but I do have, I have a serious trepidation contradicting another court order, especially if it's as clear and specific as the one Ms. Montanaro is referring to. So with that in mind, I ask you to please confer and see if you guys can, you're reasonable people, come out to a reasonable result, please. And you guys need a further hearing, you call my Ms. Salas and she will give you one immediately. All right.
Can I have just another suggestion, Judge? Can we send the money to the 445th and let Mr. Garza jump onto because Mr. Garza, Trey Garza was Mr. Slovak's family lawyer.
Okay.
And like I said, he's got good faith defenses to whether or not he owes this. I don't think he does, but can we just give the money to Judge Rincones and let them figure it out?
problem with that, Ms. Montanaro?
I don't have a problem with it, but I'm not going to agree for Mr. Garza to jump in and represent him in a post-decree proceeding. So, Mr. Green, I don't know. You're going to have to talk to Mr. Garza because
But
He's
I don't know.
right. He's the lawyer. I don't understand how you could have an objection to that.
Like I said, I don't have an objection, but if I was Mr. Garza, I would want to be present so I can have my voice heard as to whether I represent my client or not. Common courtesy.
Right, but I'm not a family. In other words, he's going to have another lawyer in that proceeding. I just want
Correct.
out of.
And whether he does or not, I don't know. The divorce has been finalized. I was hired by Ms. Slovak specifically post the divorce decree to represent her in this proceeding. I don't know if Mr. Garza has been hired for the same.
All right, well, within this proceeding, whatever you do in this proceeding, the conversation you all are gonna have is certainly going to affect the other proceeding. It may go by the wayside. So you all talk in good faith. In light of what I just said, please try to confer and see if you can see common ground somewhere. I
Yes,
would
Judge.
appreciate that. If you fail, if whatever, you can come back to me and I'll give you a hearing immediately. Okay?
Thank you.
Thank you. Thank you both.
May,
Thank you,
may
Your Honor.
myself and my client be excused, Judge?
Yes, ma'am. Thank you.
Thank you.
Slovic.
May we be excused, Your Honor?
Yes, thank you.
Thank you.
All right. All right, let me go to the criminal hearings. 2021 DCR 1552, State of Texas, Daniel Morales. Mr. Benton, good
Yes, good morning, Judge.
morning.
Judge, Mr. Morales should be on. I believe he's listed under Daniel.
Okay, Mr. Morales, raise your right
Right
hand. Okay, there you are. All right.
Yes, sir.
What are we doing on this one?
Judge, this case was just indicted, I believe, in September or October. I still need to get some discovery, videos, etc. I think they're all done through evidence.com right now, Judge, but I would ask for a reset.
How long do you need,
If
Mr.
possible,
Benton?
Judge, if possible, to ask for an in-court date. I have no idea when that's going to start back up. Hopefully, early
I'm
March.
gonna have to set you, to be on the safe side, I'm gonna set you for like March.
That'd be perfect, Judge.
All right, give me a date in March, Mr. Salas,
Oh, let's set it up for an office and trial, Judge?
for trial,
Okay, let's set it up for March the 7th.
March the 7th.
That'd be perfect, Judge.
All right. Thank you, Mr. Morales, for coming. March the 7th at 8 o'clock again, okay, sir?
Okay, sir. Thank you.
Have a good day.
You too, sir.
All right. 2020 DCR 140, Kevin Torres, Mr. Benton.
Yes, sir. Good morning. Mr. Torres is on. He's listed his iPhone. Yes. Judge, again, I just need a little bit more time. I need to discuss this case with Mr. Janis. It is getting a little old. I am aware of that. I wouldn't object to being set for status sometime earlier than March, but if you wanted to give me the same date, Judge, we'll try to get this
File
done.
date, March 7th. And if you resolve it before then, please feel free to call Ms. Solis so we can set you on a docket and take care of the matter.
Sounds good, Judge.
All right. Thank you, Mr. Torres, for being here.
So, when do I have to show up or?
Mr. Torres, you need to call my office. You have my number.
Okay, so, all right. That's
Call my
fine.
office. We need to talk about a few things. Then we have to be back in court on the 7th of March.
All right, that's fine. Thank you.
Go ahead, call my assistant. Okay, thank you.
All righty. Thank you.
Thank you, Mr. Benton.
Thank you, Judge. You all have a good day.
You too. 2020 DCR 1477, Oscar Varela, Mr. Rendon.
Judge, good morning. Aaron Rendon on behalf of Mr. Varela. I've received an offer from the state judge. It's a very generous offer. I just need a little bit of time to go over that offer with Mr. Varela. If I can have a few weeks, Your Honor.
A few weeks? All right, Ms. Salas, give him a couple of weeks.
Okay, let's set it up for February 14th.
February 14th. And Judge, if it is a plea, we'll make sure to have all the plea paperwork in before then.
Thank you for that, Mr. Rendon. Appreciate it. Have a good day.
Likewise, Judge. Thank you.
Thank you, Mr. Varela. Thank you. Mr. Varela.
Yes, Your Honor.
Thank you. You can, we reset it for February the 14th to take care of it, okay?
Thank you, Your Honor.
Thank you. Have a good day.
You too.
2021 DCR 2143, State of Texas, Robert Ramos. Mr. Delgadillo.
Yes, Your Honor.
Good
Good
morning.
morning. My client is present in my office.
Okay,
Ready
what
for
are we doing with it? It's a plea?
Yes, Your Honor.
You have the paper?
I believe the staff has a paper.
Okay, well, let Ms. Ramirez do her thing and we'll be right back to take it, okay?
Okay, thank you, Your Honor.
Okay, Mr. Robert Ramos,
Yes, ma'am.
did your attorney explain this paperwork to you?
Yes, ma'am.
Do you have any questions for your attorney?
No, ma'am.
No? And is this your signature?
Yes, ma'am.
Okay, thank you, sir.
Alejandro,
Yes, ma'am.
this is our last case. And he speaks English, so we will not need your services today.
Thank you very much.
We appreciate you observing, though. Thank
Bye.
you. Bye-bye.
Have a very good day.
You too.
All right. Have you sworn in the defendant? Mr.
Raise your right hand, sir.
Ramos, raise your right hand, sir. Mr. Ramos.
Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am.
I'm sorry?
I do, yes, ma'am.
Thank you. I'll just need you to speak up a little bit since you're wearing a mask, okay?
Yes, ma'am. I'm sorry.
Thank you.
All right. This is the state of Texas versus Robert Ramos, 2021 DCR 2143. Is that your true and correct name, sir?
Yes, sir.
Mr. Ramos, you're in front of me because they tell me you wish to enter a plea of guilty to certain charges this morning. Is that correct, sir?
Yes, sir.
What are you pleading guilty to? What are you telling me you did, Mr. Ramos?
I was caught with a controlled substance, sir.
Can you remove your mask for a second?
Yes, sir.
What was it?
I was pulled over and I had a controlled substance, sir.
Okay. Possession of a controlled substance. In your case, do you understand that that's been a state jail felony reduced to a Class A misdemeanor, the penal section 1244B, which calls for confinement in a county jail for a term of up to 1 year. In addition, I can impose a fine not to exceed $4,000. Are you aware of that?
Yes, sir.
All right. Are you doing this freely and voluntarily, Mr. Ramos?
Yes, sir, I am.
All right, Mr. Delgadillo, is there any need to rearrange Mr. Ramos?
It's not necessary, Your Honor.
All right, sir. Mr. Ramos, understanding what you're pleading guilty to, understanding what the range of punishment is, I now ask you in cause number 2021 DCR 2143, what is your plea to the charges of possession of a controlled substance, a state jail felony reduced to a Class A misdemeanor? Guilty or not guilty?
Guilty, sir.
Are you a citizen of the United States?
Yes, sir, I am.
Are you pleading guilty because you're in fact guilty and for no other reason?
Yes, sir, I am.
Okay. Are you pleading guilty out of any persuasion of fear, hope of pardon, force, threats, or promises of any kind?
No, sir.
All right. Have you ever been in a mental hospital or treated by a doctor for any mental disorders?
No, sir.
All right. Mr. Delgadillo, you find Mr. Ramos competent and able to assist you in all defenses he may have?
Yes, Your Honor. We've met a few times and we discussed this case in depth, and I find that he was competent and able to assist in his defense.
All right. Mr. What is there a plea agreement with respect to Mr. Ramos?
There is, Your Honor.
What is that?
The agreement is 12 months in county jail, probated for 12 months under the 1244B.
All right. Mr. Ramos, do you understand that recommended sentence, that the decision of whether to follow it or not is totally only up to me? Do you understand that?
Yes, sir, I do.
All right. If I refuse to follow that agreement, I will allow you an opportunity to withdraw your plea of guilty and take back the plea of guilty you just gave me as if you did not appear in court today at all. And I'm going to ask you to go to a jury trial for the jury to determine your guilt or innocence. Do you understand that?
Yes, sir.
All right. The flip side of that coin, Mr. Ramos, is if I accept it the way you know, or that it's your understanding, 12 for 12, if I accept it, you may not appeal your case without the court's permission, except in the pretrial motions that Mr. Delgadillo may have filed on your behalf prior to today. Do you understand that?
Yes, sir.
All right. In that case, I'm going to find that your plea of guilt is freely and voluntarily made and that you're competent to stand trial as the state to produce evidence to substantiate the plea in this case.
Judge, at this time, state offers exhibits 1, 2, and 3 into evidence.
I have no objection, Your Honor.
All right, they'll be admitted. Mr. Ramos, I have in my hand a set of documents in your case that is commonly referred to as a plea packet. It consists of 3 exhibits. Exhibit number 1 is a 9-page document, and on page 7, there's a signature line. There's a signature already on there. I want to confirm, is this in fact your signature, Mr. Ramos?
Yes, sir, it is.
Okay. Mr. Ramos, are you aware that on this documents, and in this documents that you have signed, that do you understand that you're waiving all your constitutional rights to a jury trial, a right to remain silent and not to incriminate yourself, your right to confront your accusers in open court, and further, you're also telling me that you are agreeing, stipulated that exhibits 2 and 3 are true and correct copies of the incident arrest reports that were generated as a result of your arrest. Is that correct, sir?
Yes, sir, it is.
All right. In that case, the court's going to find you have voluntarily and intelligently waived your constitutional and statutory rights, and the evidence offered by the state does substantiate your plea of guilt. The court accordingly will find you guilty. Mr. Janice, what is Mr. Ramos's background?
Judge, I don't see any background for this defendant.
He has no priors?
Hold on, just a quick glance, Judge. Hold on. Hold on. I'm confused, Judge. Can you give me just 20 seconds?
You're confused?
Yeah, there's like two different papers in here, so they kind of contradict each other. I'm just gonna give a detailed look. I don't know if it's
Ramos, have
juvenile.
you been in problems before?
He
Have you
has
been in trouble before?
He's had
in
a federal
99.
POM case, Your Honor.
Huh?
He has a federal POM case, possession of marijuana case, and he served 10 months for that.
No.
That is correct, Judge.
Is that it?
I do see back in 2016, if I'm not mistaken, a ag assault.
It was
got a very.
It's a misdemeanor assault.
Okay, it must have been busted down.
Yes, Your Honor.
That was the confusion, Judge.
That's it?
That's it, Judge.
Mr. Ramos, what am I doing with you? What am I doing with you? Why do you want probation?
Well, I'm trying to get back on track, sir. I just got out of the hospital from 4.5 months. I was dying. I'm struggling right now to hold my apartment and get back on my feet, Judge. But the good grace of God and His infamous ways cured me of my infection, and I'm trying to get back on my feet. I'm working, staying out of trouble. I've had enough of that life, and I'm trying to change my ways, sir. I have family members, friends, everybody supporting me, helping me out in every way I can, and I'm going forward with my life, sir.
Well, I gotta tell you. How old are you, sir?
I am 56, sir. I have multiple surgeries, back surgeries, spinal stenosis, diabetes, high blood. You name it, I got it, sir. I'm sick.
Mr. Ramos, you're standing and you're alive, and that's a good thing.
Yes, sir, it is.
And because of what you just said, the grace of God, you're standing and still alive. It's time you take control of your life, Mr. Ramos. I will go along with this plea agreement, but I will ask you not to come back and see me.
You will never see me again, Judge, only at maybe a barbecue. You vote for it.
Hopefully it's a tasty one. How much was the amount, Mr. Janice?
Less than a gram, Your Honor.
0.29 grams.
Wow, you all have to scrape the paper to get that, huh?
Yeah, it's a minuscule.
Well, I want to change the plea agreement and I want to reduce it to 6 months. All right. Any objection, Mr. Janice?
No objection from the state judge.
All right.
Thank you, Your Honor.
Court will find him guilty. The court will assess the punishment for 6 months confinement in county jail, place him probation for 6 months under the following conditions. Number one, he's to be drug tested. I'm gonna give you the conditions, Mr. Cortez.
Okay, Your Honor.
Pretty much know where I want to go. I will definitely want him to have urine tests for any drugs or alcohol, please.
Yes, Your Honor.
6 months. I want him to report. And that's it.
Okay, Your Honor. May we have a phone number?
And I'm going to reduce the probation fees to $40. Yes, you have a question, Mr. Cortez?
May we still have a phone number for him?
Yes, sir. I'm fixing to get that. Mr. Ramos, you need to give me a phone number where you're going to be found at all times while you're on probation from my court.
Yes,
Give me
sir.
that number.
956-312-2071. I've had that number for 15 years now.
Okay, well, you keep it for another year while you're on probation for me. All right? Anything, and I'll give him 180 days to pay the court costs. Anything else, Mr. Delgadillo?
That concludes my business before your honorable court, your honor. May I be
Have a good
excused?
day, sir.
Thank you, Judge.
Thank you.